I'll do the housekeeping. Welcome committee members, liaisons, and members of the public to the Legal Services Trust Fund Commission Rules Committee meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raise hand feature. Please utilize this tool to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. A friendly reminder that this is a video conference, and please be aware of the surroundings behind you. All Legal Services Trust Fund Commission and committee meetings will be recorded and posted to the State Bar's website. Zoom captioning is available. To enable, select live transcript, and at the bottom of your Zoom screen, then select enable live auto transcript. Thank you.
Thank you. And can we do roll call?
Sure. Alakani, Alsaroff, Blakemore, Campbell, Connolly. Oh,
there's Jack.
I'm here.
I just
Sorry.
promoted Jacqueline.
Thank you. Hi, Jacqueline. We were just taking a roll call. I connect you as present. Thank you.
Yes, thank you.
All right.
Awesome.
Galkin.
Well, then let's go forward. Do we have anybody who wants to make public comment?
Oh, sorry, patience. I'm still taking a roll call.
Oh.
Yeah.
I'm ready to go. All right.
Sandville.
Here.
Milrod.
Here.
All right. I'll go through our liaisons. Selena, I see that you're here. Don't see Melanie. And then I'll just note State Bar staff later. So we have 5 members present and we have quorum. Thanks, patience.
Thank you. Is there anybody waiting to make public comments?
No one has their hand raised.
Well, then let's go forward. It looks like the first thing that we need to address is approval of the July 17th, 24 minutes. Do I have a motion? Well, I guess first, are there any amendments or comments or corrections to the minutes? No. And do I have a motion to approve them?
I'll go ahead and make that motion.
Thank you, Jason. 2 seconds.
Second.
Thank you. All right. All in favor?
Oh, sorry, patience. We take roll call vote for motion.
Oh, the thing of this. Okay, please.
All right, no problem. Alakani. Sorry, Jacqueline, I think you're muted. We're just taking vote for the minutes.
Sorry about that. Yes, I approve.
Okay, thank you. Alsaroff, Blakemore, Campbell, Connolly.
Yes. Sorry.
Okay, Galkin.
Yes.
Danville.
Yes.
Milrod.
Yes.
Yes. Okay, that's 5 yeses, 0 no's. Motion passes.
Awesome. Okay, then moving to the substantive matters, there's recommendations regarding program quality controls and non-compliance requirements. And I think somebody's going to make a presentation. Jennifer, Heidi will discuss.
Yeah, so we'll promote, Kim, if you can promote Heidi and Jennifer, and we can start their presentation. All right, great. And then Heidi, I think you're sharing screen for the item 7.1. Okay, wonderful.
The floor is yours, please.
Okay, so I'm actually going to be leading, I'll kick things off, but this is our item 7.1, which is to approve the recommendations regarding quality controls and noncompliance. Working groups members are Jacqueline, Erica, Jason, and Jonathan. And then we'll go to the next slide. Okay, so just as a reminder, this topic was discussed by the Rules Committee at its July 17 meeting. Those recommendations were not approved in July, and feedback was provided. So the working groups sort of went back to their drawing board and are now going to be presenting the updated recommendations. So in terms of our agenda for today, we're going to just briefly, just a refresher on the topics at hand, talk about the current practice, share updates from the working group and the community feedback on the updated recommendations, take a moment for discussion, go through the proposed rules, and then, if amenable, share the proposed resolution for approval or for recommendation today. Next slide. Just as a reminder for the quality controls and non-compliance codification topics at hand, just itemized, how should the rules define quality controls? What quality controls are required for trust fund program grant recipients? What should be the procedures for both State Bar staff and the Legal Services Trust Fund Commission to address grant recipient non-compliance? And then what action should be available to the Commission when they're faced with severe, recurring, or unresolved non-compliance issues? Next slide. Just a refresher for current practice and how both topics are handled. In terms of quality controls, both currently grantees and applicants must answer a series of questions that are reviewed annually as part of the IOLTA and EF application process. Specifically, a couple of forms called out. You have your quality control review, where they answer a question, staffing and volunteers in Form 3, certificates and assurances, which are attached as part of the application. Then we also ask grantees and applicants to upload a series of documents in their organizational profile. The annual IOLTA and EAF budget review process also has a quality controls compliance component, which I believe might be in a different form now, but the questions are just regarding compliance assurance. And then Office of Access and Inclusion staff conduct regular monitoring visits with grantees to determine whether those grantees are in compliance with the IOLTA statute, the State Bar rules, grant provisions, standards for financial management systems and audits, and the ABA standards. Next slide. In terms of non-compliance and currently how that's handled, currently the Commission and the committees review quality control and related non-compliance concerns on a more of an ad hoc basis. And then they make those recommendations and take action accordingly. Substantive eligibility concerns are reviewed by an eligibility and budget review committee working group. And in some instances, then elevated to an eligibility review conference, also known as an ERC. This ERC working group makes recommendations to the EBR, which then makes recommendations to the Commission. So just a quick update on the working group and community feedback. Next slide. So on July 17, just as a reminder for this committee, just sharing what the working group had initially recommended back in July. So high level, keeping it high level, this working group proposed a definition for quality controls. They also suggested codifying a list of requirements to demonstrate State Bar approved quality controls, which included a reference to our audit requirements. They also proposed requiring grant applicants and recipients to ensure that subgrantees maintain adequate quality control standards and procedures. And there was also a suggested list of actions available to the Commission to address serious non-compliance concerns. Committee, just to sort of capture the feedback from that Rules Committee that the committee had shared with the working group, there was a recommendation to update the definition to foreground safeguarding the delivery of competent civil legal services, and to make it clear in the proposed definition that an applicant's or grant recipient's quality controls and standards must comply with all State Bar rules. There is a suggestion to define organizational infrastructure. This committee had also requested a more thorough explanation of the typical quality controls review process. The committee had also requested removal of the requirement for grant recipients to submit timely, complete, and accurate audited financial statements because those already, the rules already required it. And then there was also sort of a substantive suggestion of coordinating with the fiscal codification working group to sort of think through the recommendations regarding necessary financial controls. All right, so taking all that feedback and sort of revisiting the proposed rules and recommendations, the working group revised the definition for quality controls, ended up deleting the phrase organizational infrastructure. And then as you'll see in the meeting materials on attachment B, provided a more thorough breakdown of examples on how guidance regarding the proposed rules could be provided to grantees and incorporated into their grantee handbook. Also, upon sort of further review of the initial recommendations and also recognizing that I think the initial recommendations had just covered Rule 3.661, there was sort of an expansive move to also include 3.681, which encompassed grantee responsibilities regarding internal controls, and those are incorporated in this working group's recommendations. There was the working group also added a non-compliance review process to 3.661, and then it included fiscal internal controls updates. Okay, I'll take a pause at the prior slide just to see if there's any questions. We're just trying to recap and capture sort of the main points from the July meeting and just showing like how the working group sort of took that feedback and incorporated into the updated recommendations. Any questions so far? I'm doing a lot of talking, so happy to pause for a moment. Okay, so we'll just move forward then. And then feel free to, any of the working group members, feel free to chime in too if there's any other context or anything you'd like to add. So I'm sorry, Heidi. Okay, just to capture, so the updated recommendations and the updates to the proposed rules was then circulated to the legal aid community, and feedback was received on October 15. Most of the feedback was related to specific processes or clarification regarding certain terms and phrases used in the proposed rules. I'll go through 1, 2, 3, 4. There are 5 main points, and I'll just briefly sort of discuss them. One point of feedback, a request was to increase a minimum response time from 5 to 10 days. There were concerns about a rule in 3.661 that the commission could terminate a grant before taking other actions that were outlined in that same rule. The community also sought clarity regarding the word recommendation as it was referenced in several places in attachment B. The community also had concerns about the use of the term standards versus procedures in defining quality controls. And then there was also concerns raised regarding the proposed requirement for grantees to ensure that subgrantees maintain adequate quality control procedures. In terms of the working group's response to the community feedback, first update is that the working groups increased the response time to 5 to 10 days and also added language to provide examples of extraordinary circumstances. And then in 3.661, just in terms of processing and sequencing, sort of clarity was brought for that rule to say that the commission would first engage in those actions and steps to address noncompliance before considering terminating a grant. The working groups also updated attachment B that removes all references to the term recommendation to clarify that all of the listed items that were included would be requirements. And then sort of a definition in response to that other feedback is that they updated the reference in Rule 3.661 to encompass both the quality controls and quality control procedures in the same proposed rule, and then also remove the word written in Rule 3.681 regarding subgrantee requirements. I think it's probably would be helpful to see the actual proposed rules. There were several places, so now Jennifer and Heidi will be sharing screen to show both 3.661 and 3.681 respectively, so you can talk about it as a group.
Can you see the rule?
Yes.
Okay, thank you. So I will take off. I will start here with 3.661 and go through some of the changes that have been updated. So starting with I can't see the rule now though, so hold on, let me let me make sure my screen's bear with me 1 second. There we go. So starting with, oh, I'm at the bottom, I apologize. Okay, so starting with 3.661, section C, this is where the additions for the process for addressing noncompliance was added. So it seeks to codify the current practice that were related to findings that are identified up now and sort of make it a rule. So starting with 3.661, section C 1 through 7. Section C section C part 1 goes through and details what the procedures are when issues are defined or identified, as part of the monitoring process. And section 2 defines what the process is for issues that are identified outside of the monitoring process. And then going down to section 3, I mean, then the main difference between the two is a timing issue. Whereas you have 60 days to reply to a monitoring visit findings, the time frame may be different in findings that are addressed outside of a monitoring visit. So the first step is the staff will determine if the grantee has, I'm sorry. Both of those terms, the two above, provide a response period for the grantees to respond to the identification of the initial findings. Once staff has reviewed the response, they can make a determination as to whether or not that resolves the finding, or if further action is necessary. And then also, if it is resolved and it was a significant finding, that would be reported to the commission. So there's additional steps that the staff may take if their initial response from the grantee does not resolve the findings. That would include informing and or meeting with the grant recipient's board of directors, requiring additional reporting or monitoring, or requiring the grant recipient to obtain technical or management assistance. If the noncompliance issue is not resolved through that process, then starting here in section 4, it will be then elevated to the commission as outlined in 3.661 C7. In this instance, the grantee recipients will be notified of the commission meetings. And at the commission meetings, the commission makes a final determination as to whether or not there is still a non-compliance issue, and if the organization is out of compliance. So 3.66 C7 was in the prior rule, and so this is just added here, it contained here, and this details some of the steps that the commission may take if they determine the grantee is still in non-compliance. And then, so I will pause there because the next section that Jennifer will present on, but I just wanted to sort of open it up to if you have questions about this non-compliance resolution process as outlined in the rule.
So I know it's implicit in sub 5 there, but the grant recipients would also be given an opportunity to be heard at the commission meeting, right?
Yes, so that would
staff, and they're not given the opportunity to come and sit in the peanut gallery and just watch, right?
Yes, so there's the public comment process through the commission meetings, and so the grantee would appear at the meeting, and then they would make a public comment, and then depending upon the issue, the commission may or may not ask the grantees to participate in the conversation when it happens on the agenda. So that is their ability to engage in that process.
So I personally would be a lot more comfortable if the grant recipients were given the date and time of the commission meetings and the opportunity to be heard at the discretion of the chair. I mean, it doesn't mean they can, say everything and anything that necessarily occurs to them, but as it's relevant, we should have an opportunity to say where they're coming from and what they think in outside the 3-minute window that is normally granted to a public comment.
I think it is the discretion of the chair of that commission meeting to make that determination if further information would be helpful from the grantee during the discussion section. And I think that's often the common practice of our commission meetings.
But one of the problems with that is that when you leave it at the discretion of the chair, the grantee is not granted a right to speak. The grantee speaks only, except for those 3 minutes, at the discretion of the chair. I don't know about everybody else. I've certainly been in front of judges who are like, yeah, I don't really want to hear from you. So if I can keep you to 3 minutes, I will. So I don't know. Eric can give her hand up.
Well, I just like to point out though that that any entity is also welcome to provide written public comment. And so in essence, it's essentially they can provide a written letter in which they provide their perspective on everything. They're also having an opportunity to be heard before the staff. And I think there's an expectation that if the staff was not able to resolve the situation, that we, as part of the materials that we will be reviewing, will have whatever position the grantee took before the staff as well. So one of the things that we went back and forth on is the degree to which we are not, we want to ensure that there's a certain amount of due process. And that's why we have like the processes that we put in, and they have an opportunity to do written public comment and to make sure that they're aware of when we'll be making the decision. But we're also not really a court, right? And so I know I see your wince. But I think this is something that, as with the working group, we were sort of, and I believe me, I'm sympathetic. I was definitely on the side of like, let's turn this into like a kind of judicial thing. But I think what staff's feedback was, which I agree with and came around to, is that that's not really the role that we have, and that, to the extent that there is a disagreement with our decision, there is a judicial process that they can pursue through state bar court and that through the petition for writ. So this is not a situation in which, and I'll just acknowledge that if they take that method, we are obligated to continue to pay them on a monthly basis throughout that entire process. So this is not a situation where their funding is going to be in jeopardy if they continue to take the appeal. So I just flag all this to say, there is, I think we really worked to make sure there were a lot of safeguards in here, and there are a lot of safeguards even above us. So just, those are my sort of tidbits from working on the two groups.
That's really helpful. Sub-brains here. So I just want to know if whatever decision, because we will make a decision as a commission if this comes to us in this way. I assume it is not the state bar court. Here's a de novo, right? There's no deference paid to the commission's decision.
I don't think so. I think it is likely de novo at the state bar court. When it goes up to a superior court, if there's a challenge to the state bar court's decision, I think there is more discretion, right? I mean, a petition for writ of mandate is generally a little bit more on an abuse of discretion standard on factual findings, right? There's always legal questions are always going to be reviewed de novo. I am flagging that, that point. And even at the state bar court, even if there was some discretion at the factual finding level, it would be, even if it was abuse of discretion, we'd still have to show that our factual determinations are supported by the materials we had in front of us at the time.
Yeah, but the abuse of discretion standard is so, it doesn't take anything to meet it, basically.
Yeah.
So-
That's more of a question I'll say that Brady should answer, not me. I haven't studied this in depth. I know more and I'm not providing legal advice here. This is
Well, I
just
know,
my
I
sort
know.
of I know, but I gotta make my statement here. So if
So
Brady has a different view
Brady's
on
here.
this. Yeah.
So Brady, can you help us with this?
I actually, I have never seen one go to the state bar court. I don't think any ever have, at least not in the records that we have. So, I would imagine that they would pay some deference to the commission and staff since it's not their typical bailiwick.
So like, I'm thinking of a situation where there's misconduct, but it's not actually a crime, or, you know, where there is some kind of factual finding, and then to have deference when the grantee hasn't had an opportunity to really be, I'm so troubled by that. Selena, I'm sorry.
The only record we have in lax records of going to state bar court was when one support center didn't get enough votes to be deemed. So at least in terms of our records, we don't know of any organization that's had to go to state bar court for non-compliance issues. It was just a deeming issue.
But Asians, I don't think it's fair to say that they wouldn't have an opportunity to be heard, right?
No,
I'm just highlighting that like this isn't a situation where they do not have an opportunity to like provide written comments, if they haven't had an opportunity to engage with staff, that those aren't sort of presented to us. I think if what you want is like an oral argument opportunity, I mean, even and maybe we can be more explicit that they can submit a written statement that we will consider. I'm amenable to that, but like even courts don't guarantee you like an oral argument opportunity as part of being heard. So
it's definitely true. But what if we put something in there in section 6? I'm sorry, section 5, date and time of the commission meetings, when the issues will be reviewed, and an opportunity to submit written materials, a written argument, written.
Would you like me to add that? And
This is me. Like, I have no idea what my fellow commissioners think of this.
yeah, no. And my only question would be as staff is if there's any concerns about adding. I think that seems like
we as
an
a courtesy, we do
compromise.
it. If you want to put as a courtesy, this just so you all know, anytime there's an issue that's going to go before a committee or a commission, the staff informs the program to let them know, like, if they want to come and make public comments. So we already do that. If you want to formalize it in the rule, I see no problem with that. The public comment piece to make it more explicit, and that I don't see a problem with that either.
Yeah. I mean, number 5 makes explicit that we will provide them with the information of the date and time in which it will be considered, so that we're already codifying the kind of courtesy. I think it's appropriate I think it's an appropriate compromise to say that the staff will inform them that they can provide a written,
Part of the public comment.
yeah, written statement, and be explicit about that. But I want to make sure there's not an issue with that with staff.
There are state bar protocols and when it had to submit it, and maybe that's what Crystal's raising her hand, because and Crystal can go, I think it's like a day before, because you can submit it, and we have this happen, and we usually accommodating, but it's very difficult for us to get a public comments during the meeting or like 5 minutes before the meeting, because we're not monitoring emails because we're on here. So I would say the bar should be what the state bar policy is, and if we can be more accommodating, we will. But I would not set the standard any moment it comes through, because if we're not monitoring, emails within like less than a day and it gets missed, then I feel like that puts the staff in.
Totally agree that, and that makes sense to me, to just incorporate the rule that allows you to submit written comments. If this, you can submit them, and I can't remember what the time frame is.
So maybe it's like, so we'll allow like to submit written or oral public comments per state bar procedure, something like that, right? 'Cause
Perfect.
yeah.
I would be happy with that. I'm okay with that. And then presumably, if there's something substantive of concern, then commissioners can ask additional questions. I mean, there may be additional ways that grantee ends up having a chance to talk.
Yeah.
Okay, I appreciate that. Thank you.
And I'm sorry, I think I cut somebody off. Jacqueline, you had your right hand raised.
Well, you kind of you responded to what I was thinking because we have these existing opportunities already within the rules and various rules and regulations of the state bar for them to submit their feedback and be heard. You know, I'm in agreement that something like existing existing rules and regulations that allow that input will be honored. All existing rules and regulations for input will be honored. And, you're already saying that. So that's what I'm in agreement with. We already have these opportunities that already exist. And of course, they will be honored.
So Jacqueline, are you okay with the language there in blue, under 5?
Let's see. Yes. Yes, that is okay with me. That looks good. It looks like it addresses the issue, yeah.
Is there anything else on this right now? Because I know we're not done. Can we go forward, or does anybody else have any comments right on this part of it?
I think I just have one follow-up question, and this is just more for my own edification, is like, there's no restriction on how early they can submit public comment, right? Okay, because obviously I think, my soft suggestion would be is like, to the extent the staff can be like, look, the earlier you get it in, the more likely the commission, will have an opportunity to review and digest it, as long as and then are clear that like, but not no later than whatever the state bar's requirement is. Sorry, Crystal, you have your hand raised.
Yeah, just to confirm, so it is 24 hours for the written comment, but I mean, if the concerns are substantive, I think, as staff, like we would already be in discussion with the grantee and have incorporated any feedback or have attached it to the meeting materials. So like anything received before that time period would, I think, presumably be like attached to sort of the memo that's presented to the committee or commission. So we regularly do it. So I think sort of that back and forth of like how much level of detail to include when there's sort of existing process and sort of our overall state fair process was a little bit, I think, tricky in terms of like what to include in these proposed rules.
And I'll just add, like, the stickier the issue, the state bar staff, we don't like to kind of summarize what it is. We do it by necessity in the memo. We always try to get a response from the grantee so that you hear their voice, and that's what usually is an attachment.
And I really have seen all of that. I really have seen that. So I hope this is really clear that this is not a diss on you guys. It's just, yeah, given what the stakes are for the grantee, it seems like a little bit of extra hearing from them is fine. Right, and they know too that they get to speak directly. There's something about.
And I'll share this too, because like everything, and I agree with all these edits. It's already being done in practice, but I think bringing that visibility to grantees to know that they can exercise this and these are the procedures, because it might not be aware to them until they come into a situation like this. So I think this is really good for clarity. And we're like very cautious in terms of informing programs of like, what the state bar rules is, what the appeals process is. I would say sometimes to a fault. I mean, there was a situation in EBR of a reconsideration that you're here at the commission meeting. And the grantee, I think, was displeased that we had shared that there was the state bar rule that to reconsider. And so I think that committee wants this committee to kind of rethink through the reconsideration. But that, I mean, we were kind of doing our jobs and kind of informing the grantees. And so Yeah, I know this is in the good, yeah, so I just share that to share that we are very cautious in sharing with the grantees all of their kind of rights under the state bar rules.
Okay. Anything else, or can we proceed? Okay. Who's
There-
next?
Hearing none, I will take us to the end of 3.661's section 7D, or I think I'm on the wrong, the C and E. I can't remember what subsection it is. And I'll turn it over to Jennifer to address those issues.
Thanks, Heidi. So subsection D is the definition of quality controls. So we've through the working groups, we've made a few changes. First, the working group reordered part of the definition to foreground the provision of effective, high quality, and professional civil legal aid, then followed by the client protection piece as the Rules Committee requested in July. Additionally, in response to feedback from the legal aid community, the new definition makes clear that the definition for quality controls applies to both support centers and QLSPs, and the words standards and procedures function interchangeably. While we do acknowledge that the IOLTA statute does specifically reference quality control procedures for QLSPs and quality control standards for support centers, staff and the working groups confirmed with OGC that the proposed definition is appropriate and does not misinterpret the IOLTA statute and serves to ensure that QLSPs and support centers have the same standards and procedures. And then finally, the definition now makes clear that these standards and procedures must comply both with the IOLTA statute as well as all state bar rules. And then moving down to subsection E, this is the same as the July proposal, and it stipulates that grant recipients are responsible for ensuring that subgrantees maintain adequate quality control standards and procedures. I'll pause here to see if there are any questions about D or E.
We have one, but I don't know. Did anybody else have anything? So, let's go twice. Okay. So I saw in the LAC feedback, which I really appreciated seeing. And thank you, everybody, for taking the time and making the effort to make sure we can include that in part of what we're doing here. But the idea that there might be some kind of specific language that would be incorporated into a contract with any subgrantees. I really like the idea that there's a list of policies and procedures that we, the commission, provide. And I understand that everybody's bound already, and this obligation exists already, and the contracts already say, you have to obey all the rules and regulations of the state bar, etc. But I'm wondering how many grantees have any idea what that means. And I'm thinking that maybe some of you who are on the working group, if you chewed through that already, and I just don't have confidence that they do, that the grantees have any idea what they're signing on to, except, we're going to do a good job and we're not going to steal money, other than that. So I'm wondering if people have already had this conversation. Selena.
Patience, that's one of the things I was a little bit curious about too, is that how the state bar staff will be able to monitor subgrantees. Because as we know, a lot of our smaller IOLTA funded organizations kind of are still struggling to learn some of these quality control procedures. And I expect there'll be a lot of technical assistance as we have these smaller organizations trying to put into place what larger organizations may have already. And a lot of the sub-grantees that I am encouraging the IALTA community to sub-grant to are very small community-based nonprofits, especially around client outreach. And I think that there are procedures in place to make sure the funds are not misused, but they may not be able to kind of investigate all the other quality control measures. So having really clear guidance to say that the IALTA grantee needs to assure that the sub-grantee is using those funds correctly, maybe a bit more targeted than just like general adequate control standards and procedures, because that feels really broad. It almost feels like an LSD restriction to say, assuming that your sub-grantee does everything right instead of ensuring that they are spending those funds correctly.
Erica.
So I understand that there's, potentially concerns about, whether certain organizations have the quality control infrastructure that's necessary. The thing I'm a little bit hesitant about is to lower our standards about what those quality controls ought to be through and requiring that when entities take our money and then sub-grant it, that they are not ensuring all of those particular controls of the people that they give the money to. Because ultimately, right, we have to account for whether the money was used in the appropriate way. And the quality control is about making sure that they're using it in the appropriate way, right? I don't know that that those two things are sort of part and parcel. The quality controls are not just for the sake of quality controls, right? The point of them is to help with ensuring that the money is used in an appropriate way, that you are engaging in legally compliant work, that you are doing the things that you're supposed to do. So I feel like the issue may be one of what resources we can provide to help grantees and sub-grantees ensure that they are in compliance. And I also think that the way that we drafted the quality controls was not to be too prescriptive, right? To say the standards are about being reasonable in the context in which you operate. So you need a way to track your time. We are not dictating to you that you have to have the most expensive way to track your time, right? It has to be reasonable in light of the operations that you engage in. And I have, concerns about saying, well, if you give the money down to a sub-grantee, you don't have an obligation to make sure they're, to make sure that their controls are adequate. Again, when we've given flexibility about that the controls need to be reasonable in light of the operations they engage in. But anyway, I'll turn it over to staff because they may have different views on it, but I just wanted to make sure I put that statement out there.
So Jennifer, I totally get that. I have to say, I'm also watching the debate about the support centers having a cow about having to report their time. But Jennifer, and then we'll.
Thank you. So I just wanted to note that I think I agree with much of what Erica has said, but staff would encourage the members of the committee to focus for now. 3.661 is really about the commission, whereas Rule 3.681 is about the grantee responsibilities. So I think that this is an important conversation. It is one that the working groups and staff have had, as Erica has already demonstrated, but we would encourage focusing that conversation on Rule 3.681, which is where it really comes into play. This is just the point of subsection E is just to say that the commission, again, may take action against a grantee if the sub-grantee does not maintain these adequate quality control standards and procedures. I hope that that's helpful.
Well, that's makes perfect sense. I have no present recollection of when it is we're supposed to take up 3.681 if ever. So
Sure.
that's one thing. And Jacqueline, I see you. I just want to say this. As a, and I don't remember how much sub-grantee we did, but we were definitely in collaborative relationships with smaller organizations like Hoods and Doing Reach. And there was not, where these are people generally that we knew in a whole variety of ways, like you would run into them at a fundraiser, or you would attend their fundraiser, or whatever, and there are people that you respect and like, otherwise you wouldn't be dealing with them. And there's no bandwidth to go and see whether or not you're keeping track of their time. Or, there's deliverables. Basically, did they do what they said they were going to do? Do we have reason to believe they did a reasonable job at it? But there's nothing scientific that I ever detected about tracking, accountability and ensuring standards. Really, like, who's going to do that? Seriously. So it's really super helpful. It would have been for us to have every sub-grantee signs this thing, and it's part of the deal. And it's like A, B, sub 1, sub 2, C, and D. This is what it means to maintain quality control for you, the sub-grantee. So that's kind of what we're doing. Jacqueline and then Katie.
And what you just said is related to what I was going to touch on. I was under the assumption that when the grantees are awarded the funds, they have to sign a contract stating that they had reviewed the related rules and regulations, which include what we're discussing, and that they have they've reviewed those and they understand them. And also, I wanted to ask, are the grantees referred to any agencies that assist and provide trainings with these kinds of rules and regulations that we refer people to from the bar? So I don't know, do we refer them for trainings, or does anyone think that some mandatory training should be in place so that we can show that we have demonstrated efforts to make sure that not only, when they review and sign that they understand and agree with these rules, that they have, some kind of tools, training tools that they have taken advantage of. Wondering about this.
Katie. Can you hear me? I'm so sorry. There you go.
I didn't hear you.
I'm happy to chime in on that question.
That's what I was asking. Can you do?
So we do have support centers that provide guidance to our QLSP. So one of them is One Justice, and they tend to be the grantee or the support center that we send grantees to regarding nonprofit operations, as well as Selena and their team at LAC. And then in addition, we are doing increased trainings at the state bar level to sort of make sure that this information is getting out there. That is, maybe not as prevalent or talked about as frequently. And I would say that the sub-granting process at the state bar probably is one of those issues that needs a little more attention and sort of fleshing it out a little bit more, because I don't think that there is very clear guidance on what is required when you subgrant, and everything that we have to ensure, the grantee has to also ensure that their subgrantees do that. That is just, they don't lose those requirements just because they're handing it down the line. And, you know, just this week, we've had an example where in a subgrantee section, you know, there was a total miscommunication between two grantees where we had closed out the grant, and the grant or the contracted organization reported a full spend down. And then, you know, 4 months later, after the end of the grant, when it's been closed and processed, the subgrantee contacted us saying, okay, how do I return this money? And we didn't, you know, we had no record of them having the money or any, you know, any details around that subgrantee process. And so there became a lot of confusion about who was responsible for those funds and who was responsible for ensuring they were spent and all of this. So I think there does need to be some clear guidance and rules and accountability that you just can't hand money out and it can be spent however the subgrantee chooses to. They're still bound by all the same rules. And so the process, you know, just like when, you know, judicial council gives us, we are responsible for ensuring the grantees do it. So we need to make sure that we have a contract that is clear, we have expectations that are clear, reporting guidelines that are clear. And I just don't think those things widely exist right now in my view of the various subgrants that I've looked at. And so I think greater clarity and accountability is desperately needed on that topic.
Selena.
I want to just echo again what Patient said about a potential chilling effect. So I definitely agree that grantees, including when I get grants as well, that there needs to be some, I guess, clear oversight that the funds are spent in accordance with the grant. But the fact that this is maintain adequate quality control standards and procedures, that is so vague as to be an organization-wide need. And I worry that IELTS grantees will say, never mind, I don't want, you know, what if I subgrant literally $5,000 to this local community-based organization to do outreach in the community. And then I find out later that, you know, they didn't have something, like they didn't have adequate number of board members. Like it needs to be really narrowly tailored to say, ensuring subgrantees maintain adequate quality control standards and procedures to ensure the funds are spent in accordance with the grant. Something to make it really narrow, because if I were subgranting, I would say like, okay, I just want to see your QuickBooks reports. I want to make sure that it all makes sense for the $5,000 I subgrant. But I really worry about organizations just stop subgranting if they're worried about them getting in trouble for their subgrantee.
So having said all this, I also take Jennifer's point that we're not going to solve this in this rule. And I guess I don't know. Do we have 3.681 somewhere on our docket some year?
Yes.
It's the
here.
next thing that we're looking at, Patient. It's like further down the page that 3.681 is so, and I can say this because I worked on both working groups. One working group sort of handled one side of this, the other handled the other. But basically what we tried to do is say, this is the commission's role in oversight, and or define sort of what the staff could do, what the commission would do, what the sort of due process high level process was, given the feedback from the last rules committee meeting. And then 3.681 is like the substantive terms by which we will assess whether there are adequate internal controls. And, you know, to Selena's point, I take the point, but I think we have, I mean, I guess, is your recommendation that we say that we can only take action against a recipient if their subgrantee did not have adequate internal controls to ensure the money was used in an appropriate way? I mean, I guess to me that seems to sort of fold into adequate internal controls anyway, but you know, is that the suggestion?
Yes, and largely because there are all sorts of recommendations that you will have on the IALTA grantees for quality controls and procedures, including like having a, conflict of interest policy, all these policies that you really look into your monitoring visits, that I worry about that obligation not being understood for the subgrantees.
But then why wouldn't a conflict of interest policy be part of an adequate internal control to ensure the money is used in an appropriate way, given that a conflict of interest policy is a way to ensure that that there isn't sort of a problematic issue with the operations of the committee? I guess what I'm saying is that in theory, the quality controls are about, and internal controls are about ensuring that the money is used and that the operations of the entity are being done in a way that ensures that the money is being deployed in a way that's appropriate for the grant. And so I guess I would say, like, I would have concerns even with $5,000 if the sub-grantee doesn't have a conflict of interest policy. What ensures that they're making sure that their staff and their board doesn't, and it's not exactly like I'm saying a conflict of interest policy.
But think about what that means. Think how it is that the state bar does its monitoring visits. I mean, it's like a colonoscopy, right? I mean, it takes days and sometimes weeks, and it's, it's really thorough, and it's really like recipients are not in a position to get down into their subgrantees business on that level. So really what we need is a set of basic criteria, and something better than you did not go to Tahiti with the money, but something that, like just, and we don't, like, if we have an agreement that this is a good idea, we can defer it to Rule 3.681. We can do that. That seems like to make more sense, as Jennifer has suggested 20 minutes ago.
I don't think that's right, because what we consider, because 3.681 is what the grant recipient's internal controls should be. And what we seem to be saying right now is that we do not need to hold sub-grantees to the same standard.
No. What we're saying is we need a functional, workable set and clear, not vague, clear, specific accountability criteria. So everybody knows what the hell is expected. And so everyone has good notice of what exactly is expected and under what circumstances the grantor, the recipient grantor is going to lower the boom on the subgrantee, right?
I mean, I agree with you, but I don't think that's what Selena is asking for. And maybe Selena, you can clarify, but I think the way we even said it is that 3.681 is the clear standards that we want to incorporate with regard to subgrantees. And it sounds as if what Selena is suggesting is we should not be incorporating all of the requirements of 3.681 as oversight for grantees to subgrantees, because that would chill potential subgrantees from taking the money because they don't want to comply with all of the requirements that we have imposed. Is that right, Selena, or am I wrong on that?
I think that the practical effect will be that we will lose a lot of subgrantee opportunities because of the intensive monitoring needed by the IALTA Commission to ensure quality controls and procedures. I think that, like, there's a level of, like, adequate that is really different if it's $5,000 versus $1 million grant, where a QuickBooks report and a list of staff, like, that may be enough for me to know that my subgrantee spent the $5,000 appropriately. But if it was a very large subgrantee, like the word adequate here, I think could be interpreted by commissioners. But to Patient's point, like, it has to be really clear, because the chilling effect is really real, where subgrantees won't want to take the money, IALTA grantees won't want to subgrant the money. And so there has to be really clear, like, this is specifically what we're looking for in subgrantees of any grant amount, or when IALTA amounts go down again, then the opportunity to subgrant will be even smaller. So I guess
so if we threw a cross-reference into E that said adequate quality control standards and procedures as defined in 3.681. Would that satisfy what you're saying?
I don't know. I don't want to make this decision right now because I don't have 3.681 in front of me. It's not technically on the table.
Okay, so maybe we should go to 3.681, see what those standards are, and then we can come back to whether, as a subgrantee, they should be obligated to those same standards or not.
And my, my goal is not to lower standards. That's really important. It's really important. I think we all agree that.
I understand, and I'm not insensitive to Selena's point, which is like what we have put in 3.681 is a very rigorous standard of controls that we expect our grantees to satisfy. And I think what I'm hearing from her, and I'm not saying I disagree with this, but I think we need to discuss it, is that requiring a grantee to ensure that a subgrantee meets the same rigorous level of controls is what would chill. And so maybe we need to look at 3.681 to discuss whether we like that even as for as grantees. But that I just want to highlight that I think that's what I'm hearing, is that there should be like a subset or something that should apply to subgrantees.
If form should follow function here. I mean, really, it should be Selena, you wanted to add something?
Oh, just a friendly amendment to have, as Erica just suggested, a clarification on the types of quality controls and procedures expected of subgrantees versus grantees. I think that would be making it really clear and transparent. So no one's worried about getting in trouble, because we can all think of small organizations that do really great work, but maybe they had quality control procedure issues with their other funding.
Jacqueline?
It seems to me, and what I'm hearing is it seems to me that we want to really make sure that the grantees and the subgrantees have a really good understanding of our state bar rules and regulations. And also, I mean, when they review these protocols, I mean, if they have to sign a contract saying they reviewed and understand and are in agreement, we want to also be sure that they fully understand what they have reviewed. And, I was just thinking, there's an agency that when I was on the board of a local nonprofit, there's an agency called Public Counsel, and they do customize trainings and help people with these kind of things. And I'm just wondering, and they did it for our board. And I'm wondering, would it be helpful to partner with an organization like Public Counsel? You probably are familiar with Public Counsel. It's the largest, pro bono community legal organization in the nation. And they do customized trainings, and maybe this is an area where we could partner with them to provide assistance to the grantees and subgrantees and work with them on what areas they need to fully understand, and to help them to strengthen their ability to comply with all of these rules and regulations that we have for the grants. What do you think about that? Is that something we've ever done before or considered? Does that fit within our bar association related rules and regulations? Can we do that? Can we consider that?
I can see that working. Selena?
Well, my response to that is Public Counsel is one of your grantees, but I would be really hesitant to ask grantees to do work that's not part of their current priorities. We're all reeling right now from the election yesterday, and Public Counsel will probably engage in their own kind of strategic planning over the next few years. And they may be really, really leaning on pro bono counsel on immigration issues or other issues impacting folks in Los Angeles County. But I definitely recognize they do a lot of work in this area. But my strong belief is that if we are if y'all if the IELTS Commission is asking grantees to have quality controls and procedures, part of that increased technical assistance is answering questions. And so I think that State Bar staff is the best position to say, here's what we're actually looking for. But public counsel, I acknowledge they do a ton of that work for sure.
So I think we all agree this is a need. We're not going to satisfy it today. If we could be sure it's part of the conversation about 3.681, that would be, I would really appreciate it. I'll just like upfront tell you my goal is a short list that gets incorporated into every subgrant. And it's, you know, I don't, many of our subgrantees, the EDs, English was not their first language. I promise you, I'm sorry, but they did not go and read this trust fund, state bar rules and requirements and, you know, no, that did not happen. So let's make it easy for everybody. Let's make it really work. And, you know, in a practical way to protect the funds, protect the clients, to get the work done. And I'm confident we'll figure that out, but we're not going to do it today. But I wonder if, first, are there other comments?
Why don't we look at 3.681 since it is one of the things that we're set to actually vote on today?
Oh, there it is. Yes. Drain damage. Sorry.
No, you're fine. I don't want to, we've worked like a lot on both of these. So I want to make sure we actually like discuss this and see, you know, because we think these standards are really quite important and are basically reflecting what is already done in the monitoring. We, you know, I think Jennifer and Heidi have done a really great job and the whole team, but in the bottom is like, we had a whole chart where we basically said, this is already in, we already do this, you know, here's maybe something where we're stretching. What I think the goal with this rule is to be very transparent with what the expectations are so that we're like not having surprises later. But anyway, I turn it over to Jennifer, I think, who is going to talk to us about it.
Well, before we do that, do we have a motion on 3.661? Unless people have other comments about that. Do you want to do these together? Is that your preference? Can we do it as one?
I defer to staff on this. I think we had sort of, I had the impression we were sort of putting these together. And so I thought we would sort of go through the two because I think they work together. But if staff thinks there's an opportunity to do a vote on one, I think, you know, I'm happy to make that motion as someone who supports the rule.
Well, why don't we do that? If Eric has made the motion, is there a second?
Patience. I mean, it seems to me, and I think this is probably fair, and I haven't been involved in the discussion, so I defer to other people who might have thoughts. But if there's a change that we might want to include in E, for example, to add a reference to 681, I think I'd prefer that we go through 681 first, have that discussion, and then maybe revisit. You know, I'm not suggesting there needs to be the one motion, but maybe we revisit whether there's some additional language that we put in 661.
That makes sense to me. I think it's probably good for us to look at the standards that we, at least in E, anticipate would be applied against subgrantees, and then we can have, I think, a conversation about, are they appropriate against grantees, which I think they are, and are basically already incorporated against them. And then discuss, you know, Selena's point, which is, should all of them also apply to subgrantees with grantees being held responsible for that? So yeah, why don't we go through, is patience up to you, but it might be good just to see what we put together on the standards.
And
So
Yeah.
let's go ahead and do that. If we add a reference or we don't add a reference, yeah. So, staff, who's going to talk about 3681? Are we ready to do that? To move ahead to that?
I think so. I'll start if Heidi, thank you. Okay, so I'll be talking about the first few subsections. Rule 3.681 is duties of trust fund program grant recipient. So as you'll see in subsection A, we have just expanded this to stipulate that grant funds may only be used for allowable costs for activities for which the grant was awarded, and as applicable only in the county, excuse me, not the country, in which the grant was awarded. And then moving down, Heidi, if you don't mind. So now I'll talk about subsections B and C. These were largely pulled from the July rules proposal. However, they were kind of consolidated. Before, these were several different sections. We've now made them into B and C. They were originally proposed to be in Rule 3.661, but as we've discussed, the working groups felt that they better aligned with 3.681 to make clear that these are duties of grant recipients. So broadly, paragraph B is about governance and oversight, whereas C deals with service provisions and client protections. I can pause here if there are questions about any of these specifics.
So it's Catherine. Sorry to have joined late. I just have one question and I have yet to find my raised hand button. Oh yeah, here it is. I can raise my hand.
Catherine.
Okay, thanks. Sorry. So I like the framework for it. I think you've done a great job. I think my question is, you've identified specific policies and procedures that are currently required and embedded them in this rule. And while I understand it includes, but it's not limited to, like, I guess if we're including workplace harassment, discrimination, protection of whistleblowers, et cetera, are there, I guess, is it your judgment those are the most important things to call out? There aren't other things that currently exist in law that we need to call out? I guess, how did we end up with this list of these particular items? Because I think the law can change and there will be, there's like ADA, you have to comply with the Americans with Disabilities Act, and you have to make your program accessible and your website accessible, which from my perspective is something important. So anyway, I'm just trying to understand like why these, not other things.
Is there, oh, go ahead.
From the working group, I'm wondering if those of you, including staff, can talk to us about that. I think that's a really good question. Jennifer, I think I cut you off. I'm sorry.
No, I was going to say the same thing. I wanted to give the working group an opportunity to address that first.
Okay, I'll take a stab at it. So I apologize. I know you all have heard a lot from me. I think we first I'll just point out that I think we sort of envisioned 1 through 8 more as illustrations of the kinds of governance and oversight that complies with applicable laws. This is probably reflects in some ways the bias of the working group and the staff. These were the issues that I think, had been flagged as far as monitoring visits, and I'm not opposed to having other illustrative policies that the committee thinks are important that we should call out. But I would just say, I think one of the reasons that we put in like includes but is not limited to maintaining is that really it's the opening line there about governance and oversight that complies with applicable laws, regulations, ordinances is actually the standard. These are just examples so that we can be more transparent with the entities about the kinds of things that we're sort of looking at. And as I said, if we think there's additional ones that we didn't include that are relevant, or if there's a kind of catch-all language that we could add to sort of reflect that point that you've raised, Catherine, which I think is a very valid one, I'm happy to like suggest we amend it that way. But I also welcome staff's viewpoint on this.
Oh, Jason.
I'll just second Erica's comment. I mean, that it's not intended, even by its own plain language, to be exhaustive. I think the more we try to make it exhaustive, the more we undermine the intent here. I mean, I would just be as equally inclined to say, okay, if there's something that we find offensive that is singled out because something else is not, like, delete it, right? Because ultimately it's supposed to be representative of a sample of things that are frequently potentially seen. If we want to add, ADA compliance as part of that, I think that's fine. But applicable laws, regulations, and ordinances is a really broad brush. So this is just giving some examples of, I guess, common things that they need to be mindful of. I think there's some of these things where it's like, you may be surprised to learn that we're also concerned about your compliance with these things, right? But that too, right? And I think that's also a factor here, is making sure that the breadth is part of this. And if we want to add something to Catherine's point, I mean, I'm okay with that. I'm not offended by the idea. But the list of applicable laws, regulations, and ordinances, if we actually wanted to start capturing everything, I mean, I think we'd all be here all day, trying to think of all the things that people have to comply with to do what they need.
Yeah, I'm not suggesting that we list everything. I don't even think that's possible. I guess the thing that stuck out to me was Americans with Disabilities Act compliance, which I think is helpful to remind people who aren't steeped in the disability world about their obligations as a legal services provider. And anyway, that's what I would do.
Selena.
And I would hope that in the future grantee handbook that will be amazing, that it would have be a pretty exhaustive list. That way organizations could have a checklist of like, I have this, so they would feel protected. And I also think it's helpful for the newer IELTS funded organizations who likely have some of these policies, but maybe don't have the procedures in place yet. So having an exhaustive list in the handbook, I think, is really appropriate. But here, I think this is a good sampling with the addition of Catherine's suggestion of really calling out the Americans with Disability Act as a law that organizations must follow.
Jacqueline.
Okay, so I'm wondering, because, I agree with everyone that this could be a really, really huge list and still be incomplete, considering things that we may not consider at the time that we're making the list. So I'm wondering within the current guidelines and overall, rules and regulation infrastructure for, the bar association, are there referenced any particular guidelines relative to grantees that are like, comprise like a lot of the fundamentals and, the foundations of our grant making procedures? Does something like that already exist? And if it does not exist, is there a way for us to like within, state of California guidelines, is there a way for us to reference or use as a resource existing guidelines for other major grant operating agencies in California or the US in general that we could use as a reference. Because I think, grant making, of course, we all know this is not an area that's brand new. So instead of us trying to sort of remake the wheel, I think we could refer to other major grant-making government agencies that already exist. And I think those would be a good resource for us to help guide us in developing this, more in the way that what we're discussing that we would like to see, that a lot of us would like to see here. Because I'm learning as I go along here about a lot of the different guidelines and rules that already exist. And so rather than, sidestepping any of those, I want to make sure that I'm fully aware what exists, what does not exist. And, if we can reference the works of other major federal and state grant-making organizations, I think that would be helpful. Because I think a lot of this work has already been done by much larger federal and state organizations than us, at least on the federal level, I think.
Who grant billions instead of hundreds of millions, which we do. So
Pardon me?
we're responsible for hundreds of millions of dollars. So I think we qualify as a large grant making organization. And I take your point, there's no need to reinvent the wheel if we don't have to. I have a little different concern, and that is that this long list, which, so I understand the includes but is not limited to, I get that. And obviously, there are things in here like you can't have a conflict of interest, you can't enrich yourself with this grant money, including going to uni or whatever. But apart from the fact that, and I take Jason's point that it's not just illustrative, it alerts the grantee. You might not have thought this was something we care about, but we really do. So it has an educational function too. Looking at it though, right now, I'm realizing it assumes a very extensive and sophisticated infrastructure in the grantee that's capable of not only maintaining the requirements, like behaving in a certain way, but also creating policies and creating procedures and then monitoring itself for its own compliance with its policies and procedures. Number 4, policies and procedures regarding privacy, including technology and data security. Yikes, that's no trivial matter. It's not like you Google it and you can download the sample, whatever's required there. I don't even know, but it looks daunting to me. Maybe that's this, I don't know. But so I'm thinking of this in the context of the conversation we just had about sub-grantees who are even less likely to have the sophisticated infrastructure and the human capital to put into developing these policies and procedures and enforcing them internally. So this is one of those, I would feel really differently about this, and I would feel really differently about this if the State Bar made templates available. Here, this is what your bylaws have to look like this, or at least have to have these elements. Here's the policies and procedures about privacy, including technology and data security. Here are the criteria. that you must satisfy in these policies and procedures. Now, you can do other things, we're not dictating, but this is the floor that you must meet. My experience was there was not a lot of that available. And I really do understand that, it's a little bit like the federal government, the states are the laboratory of the whatever, the nation. And so certainly different organizations will come up with different and creative and appropriate ways of addressing these obligations, and that's a good thing. But the fact is, we really do believe in a floor. We really do believe there's a minimum level of compliance. Now, with some of these things, I have no idea exactly what it is, but I'm confident there's somebody who does, and that's a standard that we will be holding people to. So if we feel that way, and I say this, it's probably a good thing we're on Zoom, and I'm not saying this in person with staff present, but I think we need to provide more than we do. And I would feel really differently about this if we supplied here's the handbook for, here are the fidelity insurance policies that you need. Here's this is the checklist. Maybe you have it. I don't remember seeing it. Business, legal, and financial registrations and licenses. Some of that is obvious, right? Because kind of a bar card. But it just, it's a lot for a small organization. And it's a lot, especially if we think that we're going to import this list into the subgrantor-subgrantee relationship. It's a lot for the subgrantees. So, and unrealistic, it's not going to happen, which is also a concern. Catherine?
I guess I have a couple of thoughts. So I think there are two different issues. This is the appropriate list for grantees, and I think it's probably pretty similar to where people have been required to do for a period of time. Whether they've understood it or not is a different question. But the subgrantee question, to me, I guess I have two thoughts. One is, does it matter the amount of the subgrant? Like it seems like, are you granting 80% of your money to a subgrantee, in which case they're really doing everything you should be doing, and it's potentially a sizable amount of money? Or are you doing a subgrant for $10,000 or $20,000 so that they can help you do specific outreach to a community? And those feel like somewhat different circumstances to me. And maybe it's the grantee that, in at least the smaller grants, has to sort of say like something about like, here's why I think they're qualified and they have adequate procedures in place to do this work or something, as opposed to requiring that the subgrantee have, for a small amount of money, have all these policies and procedure, particularly if it's a subgrantee who's a CBO, which I think is patient's point of like, you're going to them because you're trying to do outreach to the Hmong community in Stockton or Fresno, and you don't have the language capacity or the connections, and you're giving them a grant for $20,000. But do they fall under a subgrantee? And if so, it doesn't, it sort of seems like a disincentive for people to then become a subgrantee. So I just think there's some distinctions, like all subgrants are not the same thing, if I'm understanding kind of who this would apply to.
I mean,
So, one thing I want to gain some clarity on is, I think it might be helpful, is to sort of understand the scope of what we're talking about, because I think there is a difference between, a vendor and a subgrantee, right? I think if there's money that's being used for vendors, I don't think that's that we need to sort of walk through this process. But where there's a subgrant, I think there's an added level of accountability that comes back up to us, right? And I think that's what is at the heart of a lot of this is that, at the end of the day, we have a certain,
Yeah.
we are responsible for how these funds are used. These are within our trust to make sure that they're used in a way that's, abides by our mandate and the things that we are, meant to protect. And the reasons why we have these governance and oversight controls for our grantees, I think remains the same regardless of the amount, in my view, regardless of the amount of money that's at issue. I think at a practical level, I understand the concern. I understand that, we want to be careful about how much of a burden we place, but we also, I think, have to be mindful of our responsibility. And I think from like a, it's hard to take off the attorney hat, but liability standpoint, I mean, I think that's where this all comes from. That's where our a lot of our focus, I think, should be is, making sure that we're being mindful of that. And I think, whether it's $5,000 or $150,000 or $2 million, I don't think the level of liability, frankly, is much different.
So is there a definition of subgrantee? Then maybe I have to take a step back to make sure that's what I sort of said. I don't know what a subgrantee is versus somebody I'm just doing a contract with. And so maybe it would help me to understand at least. And perhaps you did this, in which case just tell me what page I should be looking at because I joined late. But is there a definition of a subgrantee somewhere? I don't know what's intended by that, I guess.
I joined a little bit late too, so I don't know if staff or if somebody on the working group can speak to that. I appreciate that too.
I'll just interject briefly and say we did not define subgrantee in these proposed rules. I'm pulling up the rules right now to see if there is a definition because I'm not sure off the top of my head.
Thanks for doing that.
I think we do have a definition, Jennifer, somewhere when we're talking about subgrantee versus subcontractor, when you're talking about the old pass-through funds rule. So that may be where there's a distinction between subgrantees and subcontractors.
And then maybe that should be referenced. If there is, and we're satisfied with there is a distinction, then maybe that rule should be referenced here, and that might help all of us because I think there's I appreciate the liability issue. But from the practicality of doing work and serving clients, there is a difference between $5,000 and you need something from someone and, $500,000.
I will just add that there are definitions in the budget forms that define the subgrantee section and the contract services for clients sort of section. So those have definitions within the budget forms. I'd have to pull those to see how they distinguish them. But if we're going to make, and I just wanted to add one thing, if we're going to make a distinction about enforced requirements based on grant size, we need to be mindful that we give out some very small grants to small grantees. And I want to, sort of like be careful of taking that sort of approach to accountability and compliance because some of those smaller organizations we fund in a very small amount.
Yeah, so I think I've sort of moved away from that to say, like, what's a subgrantee? And are you still able to contract with people to do specific services? And maybe that solves it. And if there are definitions somewhere, I actually think they have to be referenced in what is now a rule that we all agree to. That's great they're on the form, but maybe we need to fold those into the rule so we all know what we're talking about. And I have a feeling it might make some of us feel better, at least if I understood what a subgrantee was.
Erica.
So I appreciate that we're talking about subgrantees, and I appreciate distinguishing the two, but I do think we need to go back to whether we're okay with these standards for grantees. Because if these are not standards that we agree on for grantees, then the subgrantee conversation changes entirely, right? Because then if we have different standards for the grantees, then we have a different debate about whether the subgrantees ought to apply to them. So I just suggest that maybe we at least come to some consensus about whether these standards are appropriate for the grantees. And if they are, then we can continue on with the conversation about whether they all or a subset or how we should apply them to subcontractors versus subgrantees. But if we're not even in agreement that these are appropriate standards for grantees, like I don't want to get into the subgrantee conversation quite yet, right? And it sounded as if earlier, Patience, you had some concerns about whether these are standards that are appropriate even for grantees in absence of extensive training and templates and stuff from the commission or some resource. And I acknowledge that. I will flag, that as the staff, did, a lot of these are things they already are supposed to be doing, right? And so I think we're just codifying things that are already supposed to be there. And I also think, my recollection from conversations with staff with the working group was that there, and frankly, I think the goal more generally with our strategic plan and everything was that the commission would be more of a resource for things like policies and stuff like that, so that we're not, I will say, at least from my perspective, and I think I speak for other members of the working group, the goal here is not to do gotcha, right? It's not to say you didn't have a cybersecurity policy, and so now we're going to take your money away, right? Like that. And I don't think that's ever been staff's point either. The goal has always been, how do we get them into a position where they have these protections, which it's true, a lot of smaller organizations may not appreciate that or realize that cybersecurity is an issue, but it is an issue even for them, right?
Or be able to afford implementing a system.
I agree. And I do want us to work with that, but I'm not sure I think that we should not include that as a standard that they need to sort of address. Our goal with this was to try to, again, not be super prescriptive, to not say you must have this specific thing. It was to be reasonable to have these policies in light of the context in which they engage, right? And so more generally, I just want to settle on, are these the right standards for the grantees? And then it's clear that we need to do more work on the subgrantees and have further discussions. But if these aren't even the right standards for the grantees, then we have a different conversation we have to have. So I should say, I have to leave it too. So you will soon not have to hear from me anymore. But
well, all right. So we'll try.
I've been on this working group for too long, so I'm please let it pass at some point. And that's fine. If we have to do more work and we have more things to do, I'm totally that's the value of bringing it to the committee and hearing a lot of different viewpoints. And you guys have given me especially lots to think about. But I will say that is, I do want to address the situations that we did think about to make sure that people understand why we accounted for it or how we accounted for it.
I just want to say one thing before I call on Jennifer and Catherine. We are our project is codification of practice, but basically how things were already working. My experience certainly was that staff didn't come in and what? They were so here, we can help you, and we're going to give you some time to figure this out, and we're going to connect you with whatever. I can't even remember, but it was a very it was the very opposite of gotcha. And once we start codifying this stuff, it has a different valence. It is different. So, so where I'm personally coming from is, yes, let's codify this if we're prepared to make it actually feasible. If we're not prepared to make it actually feasible, then we should think twice about codifying. So, Jennifer and then
Catherine. I just wanted to say that if the question is whether these standards are appropriate for grantees, then I would say that maybe we should continue scrolling because Heidi will share the fiscal side of these requirements or proposed requirements. But I would defer to Catherine, obviously.
Yeah, I guess I was just gonna, I think as a large grantee who also got federal dollars, so any other large LSC program, in some ways, the way these are written, I actually find them more understandable than anything I ever read from the federal government. So for grantees, all I can do is speak from my experience, and other people have much more experience of what is it like to be a very small grantee. I think they're fine for grantees, and my questions, once I know what a sub-grantee is, will probably be answered, right? And I think there's wisdom, Erica, in not like figuring that out until we agree about this. So, and I would say the same thing about the fiscal standards that also seem like remarkably clearly written in ways that I think a non-accounting person, like an ED, could understand. So thank you for the good work in doing kind of plain language for, accounting people people that should know accounting but don't. That's all.
Okay, Jacqueline, and then we're gonna move along to the financial standards. Jacqueline, you're muted.
Okay, it sounds to me like what we want as a group is to have, a summary listing for the grantee, like what we're seeing here, a comprehensive one that's easy to read. And like Catherine said, this is easy to understand. It's very concise. And then have a guidebook or some other kind of reference with a lot of details on each section about what is included in these sections. Like we have B 1, 2, 3, 4, 5, 6 here in summary, and then maybe we can have another reference guide that comprehensively details out what falls under each of these categories. And that would be a good reference for grantees to refer to for more details. And additionally, like, I'm with some, major organizations that provide a lot of grant funding. And one of the things we do that works well for us is that we have made online video trainings. I mean, when we first started out, we didn't have those, but it's congressional funding and congressionally funded. So we put everything online during COVID, especially was a time when a lot of people started doing a lot of that. So the grantees will have training programs that are self-guided that they can refer back to whenever they want to, whenever they need a refresher. And it's just maybe this is something we can think about doing and have that as a resource for grantees and sub-grantees as well. And then it wouldn't be such a burden on staff members to do these technical trainings all the time. And because a lot of the issues being addressed are repetitive, redundant issues for different grantees, the same issues for different grantees. And so maybe, we need to think about making some trainings online, video trainings that they can go to whenever they need, and also when they receive the grant. That's part of the requirement to go through that training. And this is in addition to what we already do in terms of technical assistance.
Thank you. Should we move on? I have in mind Erica's 2 o'clock turning into a pumpkin. So I kind of want to move this along if you can. So who's up?
Idea.
I think
Tell
it's
us
me. Okay, so starting with section D, what we try to do here is take the current existing practices as they're defined in the financial standards for accounting and audits, something like, I might be saying the name slightly wrong, and the provisions that live in the grant provisions, as well as sort of our monitoring protocols, and kind of consolidate them all into one space. We were intentionally not prescriptive in these requirements so that there is flexibility in interpreting them, but this sort of sets the minimum standard for fiscal internal controls to ensure that the money that is being given out to the grantees is safeguarded and used properly. We did look at other sources of grant-making organizations like LSC, Cal OES, different other government agencies that have various provisions. And, I think LSC's financial section is about 84 pages. So we really tried to just like bring in the minimum standards. Also, we tried to clarify things where some of the understandings had been unclear to grantees, as well as modernize some of the requirements to make it so that it makes sense in the the modern ACH payment world, et cetera. So I don't feel like I need to go through each of these individually. I'll let you guys read them, but and we can discuss sort of them. But that's the overall context of the fiscal standards that run through, or fiscal rules that run D through R. So if there's anything you want to look at specifically, we can look at each of the individual code sections, or I can open it up to any questions that we can sort of go through this together. But it is a pretty, it's not a small list, but it's not, I don't think it's an overwhelming list. And for the most part, it is, the requirements as they exist today with some clarification.
So I want to echo Catherine's compliments to the staff. I mean, this is, I went to law school, so I didn't have to do math. So this is very, you're not giving us accounting principles, but you're educating us about accounting principles. So, and it doesn't seem to me to be too long or unreasonably demanding. It's basic. And I think you've done a beautiful job with that. So, no small feat. What did you say, 84 pages or something?
Yeah, I mean, and I appreciate that feedback, Patience. Yeah, so I mean, we want it to be a helpful guide for organizations that may not fully understand sort of principles and sort of, internal controls as it relates to their operation. So yeah, so that's the perspective from which we are coming.
Good job.
Thank you.
Thank you. So I'm hoping we are not going to go through each one of these. If there's consensus on the commission, on the committee, that's what we want to do, I'm here to do that. But my hope is there's not a felt need. How do you guys want to proceed?
And I'm happy to sort of scroll a little at a time if everybody wants the opportunity to read it, if they haven't read it already. But so just, whichever method you want to take, I'm happy with.
Well, this is starting with D. Okay, Erica, go.
I just have like a suggestion on how we proceed, which is like, if we can get consensus from the committee that the standards themselves are appropriate for grantees, and that 3.661 is other than the sub-grantee issue is okay, that would be helpful, because it sounds like and then if we could just discuss a little bit more about what the sub-grantee requirement is, whether we can cross-reference or whether we need to give some thoughts like how we would define it. It doesn't seem to me that we can do that on the fly, although maybe there's a way in which we can. I have some concerns about trying to change and define the sub-grantee application like right now in an hour without necessarily like getting feedback from Black and other, and like sort of testing it. Not that I want to put this off again, but that seems to me like if we can at least get consensus that otherwise it's okay, and the only thing we need to leave that we need to address is the subgrantee issue, then the working group can go back, we can kind of come up with a recommendation and come back. But I don't know what staff's view is on proceeding in that way.
Heidi,
And forgive me, I may be forgetting, but to the degree, the subgrants show up in here, it's pretty minor. So one alternative is we delete any references to subgrantees and go back and develop a subgrantee specific rule that could either be adapted or not, so that we can look at the bulk of what's here if we're in agreement and move this forward without having to go back again. And then we could, perhaps codify subgrantee definitions, rules, and requirements outside of these two rules, or eventually would get added to 3.861, just a suggestion.
Do we still know? I still don't understand what a subgrantee is. Do we find a definition of a subgrantee that exists in a rule? Because maybe that'll just answer at least my questions.
I don't think we found a specific one. I think if I were to write one, I would write it sort of in the direction of performing civil legal services on behalf of the grantor. So it's focused kind of like on the same provisions and the requirements that we have. So it's a section of that. Whether, we could carve out, a community outreach, sort of organization that's not doing direct legal services. Maybe we could carve that out as a contractor. Because I do agree that there is a difference between a contractor and a subgrantee, but that's sort of the direction I would start with, and then obviously we get feedback from everybody else and sort of input. But
so I think then my questions become questions. For example, like on eligibility and budget review, we also often approve changes because people can't hire staff, so instead they contract with a sole practitioner in private practice. And so is our expectation that contractor who doesn't fall under staff, but falls under contracts, is now a subgrantee? And if we impose these rules, would it make it easier or harder for programs to then identify a subgrantee, because people are trying to hire people because they can't hire people and get the program done? And these are lawyers who presumably have, appropriate insurance, et cetera, right? So I guess to me, the definition is actually important. And I don't know that I think I worry that we're going to make it harder for people to deliver legal services if a subgrantee includes a sole practitioner who's been contracted to carry out part of this because the grantee couldn't hire a person to do it. And now the one people that'll actually read the rules are all the lawyers, and they're going to read this and say, I can't do this because I don't meet these standards, right? And then there's nobody.
I would say in that circumstance, they have been treated as contractors. So there's a contractor agreement with a 1099 or something, sort of arrangement where that would go. I wouldn't consider that a subgrant. I think a subgrant is more you can contract with an organization to perform a certain section of whatever the deliverables you're asking them to perform. So that definition or description you provided, I would never put under a subgrantee category, and that's not how we've treated it.
So I guess that's why, to me, whichever way we go, we approve this without subgrantee, or we approve it with, with some trying to understand what a subgrantee is. We actually have to understand what a subgrantee is, because without that, I at least don't feel like I know enough as to how I would want to vote. And it is, I certainly understand the need to protect the bar from litigation and all of that, and liability issues. And at the other hand, I don't think we want to say it's now going to be more difficult to provide legal services given the recruitment and retention challenges people face, and whether that's I don't know. So anyway, I just think we have to know and noodle through that, I guess.
Right. And I don't disagree. I do think the subgrantee conversation is a bigger conversation that I do think deserves its own subsection. And it's become more relevant or prevalent given the last couple of weeks and the various subgrantee issues that have come up that I've been privy to. And so what I would say, though, I'd like to add is this isn't just about protecting the commission and the bar. It's also about protecting the client so that we ensure that the people that are being sub-granted are, appropriate to provide those services to those vulnerable individuals. So, Jason?
Some sections probably relate to protecting the individual that's served, and some sections might not relate to that.
Yes.
Jason.
Yeah, I was just gonna say a little bit of what Heidi just said, but I'm just concerned about, well, I appreciate we have a goal of expanding the access by way of extending out our reach and getting it to the different grantees and or sub-grantees to render service. I do have a concern about us hesitating imposing otherwise reasonable expectations on grantees or sub-grantees for that matter, or subcontractors for that matter, because we are afraid of the chilling effect that it may have on providing service. Which is to say that any rule imposed or expectation imposed whatsoever will have the outcome of some potential reduced service, because someone will say, I don't want to deal with that. Right. And you could say it's not likely, but in my world, I have conflict counsel who are unwilling to represent defendants who are just difficult. Right. And they're just like, I'm too busy. Like, if there's a reason, it's out there for why someone won't provide service. Right. Unless we make it abundantly easy and have no restrictions or no expectations. And at that point, we've now gone to the other extreme. So I'm very reluctant to reduce those expectations, especially when some of those expectations are, I mean, yes, you have to get together a policy. I mean, there was one about workplace harassment, right? So if I was negotiating a contract and I was negotiating a contract for a sole practitioner and they said, well, I don't have any employees, so I can't agree to this. I'm not going to do it. My response would be, or you just have a policy that says we have no employees, and to the extent we have employees, we will follow the following protocol with regard to reporting workplace harassment, right? That's the policy. And if you can't do that, then maybe you don't deserve my contract altogether. And I think to some degree, we should take that stance as the bar in issuing grants, that these are expectations regarding the effective and appropriate rendering of professional services to the public and to those in need. And it is expected that you follow a certain level of behavior. And while there are ethical requirements for sole practitioners, that should not be the sole and exclusive means by which someone is governed. If they are a recipient, either directly or indirectly, of state bar funds.
But we've already made a distinction in this conversation between a contract with a sole practitioner to deliver service, who apparently would not be a subgrantee, and then something else that's called a subgrantee. So maybe you're speaking to the distinctions wrong, but it's why I think understanding what a subgrantee and not just using that word loosely is important. But it seems like there's a path for today to have a vote on, are these reasonable standards for grantees, and then revisit the question of subgrantees. So maybe that's the best path we can do today.
Well, I guess I would say, to the extent we're talking about grantees, if these are otherwise legal requirements that are imposed, their reasonableness is irrelevant. So that would be my 2 cents, and I would move to forward it on the same concept.
So Jason, I didn't catch the last thing you said. If these are reasonable to impose on grantees, then it's reasonable to impose on contractors and sub-grantees also.
No, the comment that I was making was that to the extent the requirements that we have, the earlier section where it said, you have to comply with laws, including but not limited to yada, 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 right? Well, if those things are compliance with laws, rules, regulations, and ordinances that are required, regardless of whether those requirements are deemed by this group to be reasonable, is not relevant. because they are required, right? And so we are merely articulating and recapturing the requirements, not making a qualitative assessment as to their reasonableness, because requirements can be adopted that are not reasonable and yet they're still required, right? And so we have to figure out how to work with them. And to the extent that is what's being articulated, then I think we still have to do it. And people still have to either, I think people, grantees will be very clear, at least grantees have a choice to decide, to the extent these things are required, whether they want to follow the requirements and pursue a grant, or determine that in their perspective, these requirements are not reasonable and therefore they will opt out of receiving a grant. But if they are required, irrespective of our choice, that's the choice.
Thank you. Jacqueline and then Catherine.
Okay, okay, so this has been a really great discussion, a lot of great suggestions and perspectives, a lot of good feedback, and really helpful to me. And so to move forward, I mean, it sounds like we've talked about policy handbooks and guidelines and the some kind of guidebook, templates. We've talked about a lot of different things. And on the prior slides where we were discussing that listing not being complete and not having a detailed details about the summary that was there. So I'm wondering, how do we want to move forward then? Do we need to because it sounds like we still have a lot more work that overall that we want to do. It sounds like all of us are all together sounding like there's a lot more work to be done on this. And which I can understand because this kind of work is always a work in progress, it's ongoing all the time. It's never like, okay, we're done. That's not ever going to be possible, I think. And so I think we're off to a good start, but there's a lot more work to be done. So how do we approve what we have done so far and knowing that we still have a lot more to do? We have to have guidelines to continue working. And
Are you making a motion?
No, I'm not making a motion.
Okay, dang.
I'm just I'm making just giving my input and suggestions about what I think. And I because we didn't address the issue that I didn't hear, like what happened to the suggestion about having a guidebook and some reference guides and these templates that you were mentioning, Patience. What are we going to do with all of this input that we got? A lot of it's really good. So where do we put all that? Is that something we're planning to keep on working on? And do we want to approve what we have here as incomplete, as we're hearing that the consensus is feeling that there's incompleteness here? So
Okay.
how do we move forward?
You could, your motion could encompass next steps. So while you think about that, I'm going to go to Catherine and Amin.
Okay, I was actually going to make a motion that we approve the rule with the addition of the Americans with Disabilities Act as it applies to grantees, and that we continue to work on the applicability of this to sub-grantees. So that's my motion.
Thank you. Who's keeping track of the motion? Did you get the whole thing? Yes, no? Okay. Not here, no, I'm gonna say yes. Okay, Amin.
I'll second the motion.
Aha, lovely. Did you also want to make a comment?
No, I was going to make a motion, so I appreciate Catherine you jumping in with that.
Great, thank you. Crystal.
Patience, do you mind? Maybe we can pull up the PowerPoint. Sorry, Heidi, and then just make sure that that language is captured, and then also reflected in the minutes from this meeting, so we can add in the additions to the resolution language.
So you want to look at the PowerPoint?
We have the resolution there, so I just want to make sure we're capturing it accurately when we do the minutes, that we have to make those adjustments.
Got it.
Sort of lost the page that the.
So maker and seconder of the motion, is this what you have in mind? Oops. Just
Sorry, let me make it bigger. Yeah, but this is.
there we go.
And this one we can edit it because this is the PowerPoint, just so
I just
Adding
wanted to reference it's 3.681
one.
section C, I think is where we're adding it. Right? Is that correct?
I have now lost in my papers where it is.
Okay, 3.681
They're all
section B. Okay. That's
section B,
okay.
I think.
Okay.
So it'd be like 9, add to section 3.681 B, the Americans with Disabilities Act. And then the second part is recommends adopting the amendments to these rules for grantees, but it's essentially deleting the references to sub-grantees in this, where I think we need more work.
Okay, and so and adopting, so tell me the last thing. I'm not a very good listener and typer at the same time, and I know there's corrections that need to be made.
I think you're doing fine. I would say recommends adopting the amendments for grantees to. How about that? You could put it up above, but either way, adopting the rules, it's fine where it is too. I'm either way is fine.
The requirements for grantees, is that what you said?
I'm just trying to apply this to grantees.
Okay.
I might say adopting the amendments for grantees to state bar rules, but I'm putting it in a different place. It doesn't really matter, I don't think.
Well, I can copy and paste it.
And are you calling for deleting subsection E of 3.661? Which is the
reference to sub-grantees?
Right.
Yeah, that's what I'm trying to do.
Yes.
Okay, so if we just do, if we were to strike this.
It's like if we're doing that.
Can I make a suggestion maybe that might address it in the resolution, maybe in a more streamlined manner? Okay, in the PowerPoint, should we just say amendments to state bar rules 3.661 and 3.681, and then maybe in parentheses with the exception of subsection E? This is in the second line.
Yeah.
Okay, so
that's where I was trying to put something earlier. Yeah. But is
so here is what you say, I mean?
Yeah.
Because really subsection E in its entirety, all it contributes is the sub-grantee relationship and accountability. All the rest of it is already in. Grant recipients are already responsible to maintain adequate quality control standards and procedures. That's already like.
So maybe staff can answer this question. Should we say sort of reserving that issue? Should we make that clear that we're reserving that issue, that we're not just?
Yeah, I mean, that could go, it could be a separate section, right? Or something. I mean, not a section, a sentence, like at the end of this or something. However you think, I mean. So it should end, right now it should end adding under ADA requirements after we figure that period.
Yeah.
And then whatever you just said sounded fine.
I guess, yeah, so I think Heidi, it would be with the exception
right
of rule 3.661E.
Right.
And so should I just strike that whole rule or that section in the rule to sort of make it clear? Is that what the intention is? I just want to make sure I'm capturing it.
That's the.
I like Damin's idea of reserving, like take out the language there and put, reserving for further amendment with respect to sub-grantees. I don't know, something.
But you should strike the whole thing, Heidi. E, strike the whole thing and then put in a mean sentence about deferring that topic, you know? I don't even, yeah, if you want to make clear.
Reserving, I like that.
Reserving, sorry, reserving.
Okay. Oh, so,
I would say reserves for further consideration.
Yeah,
and
that's-
action.
Mhm.
rules regarding subgrantees.
I think that's.
You could say the applicability of these rules to sub-grantees. And take out the the first one.
This one?
Yeah.
Okay.
And I
Okay.
just say, yeah, if you can add a comma after the subsection E in the third line,
Sure.
that would.
You are such a good sport, Heidi.
No, this is not my area of strength, so thank you for bearing with
Thank you,
me.
Heidi.
You're doing amazing.
That's what I thought. You're doing it amazing. It's hard to type in front of other people.
Yes.
So I am fine with the language as drafted as the maker of the motion, and I think Mean should confirm it's fine with him.
Okay,
That's-
Keisha, should I? Oh, sorry.
Should
Go
I
ahead,
spell out
Crystal.
Americans Disability Act in the resolution, or is it okay as ADA?
I think you can leave it.
Okay, sorry.
Well, I think that maybe, can you spell it out in parentheses right next to it? Because we didn't mention it prior. So maybe it would be a good idea to put it in spell it out in parentheses.
Heidi, it's Americans with.
It's Americans plural with.
Sure. Thank you.
And I think the suggestion was, well, you don't really need the ADA because
It doesn't come further, so yeah.
But most people are familiar with that acronym ADA. So maybe can we put that in parentheses after ACT?
Fine with me.
All right. Are we good?
Good.
I do want to, I'm so sorry. That section that starts with the addition is technically a fragment. So you might want to
Well,
tuck it.
so yeah, so
You're stuck between actually writing the legislation and taking the notes about what's supposed to be in there. So it's a challenge.
we just go like this and add it to. Oops. How's that?
Can I add it? Can I add back in the comma after requirements? Otherwise, I think that looks pretty good.
Right.
Yes.
Perfect. Beautiful. All right, maker and seconder, is this ready to vote on?
Fine with me.
I mean,
And I second, yeah.
all right. Okay. Who's taking roll?
I'll take roll call vote. Thanks, patience.
Thank you.
Alikani,
Yes.
Altaroff,
Yes.
Blakemore,
Yes.
Campbell,
Yes.
Connolly, Belkin,
No.
Manville,
Yes.
Milrod.
Yes.
All right, that is 6 yeses, 1 no. Motion passes.
Thank you. Okay, the time at the tone will be 2:18 or so. We have one more item, and that is our work plan.
And I'm going to be really quick. So usually at the last meeting of the year for the Rules Committee, the staff bring to you a draft of the work plan, and then we talk about it and we add things and we modify. We're not bringing that to you this year because there's an agenda item that you'll see at next week's commission meeting about a new structure for the commission. What you'll see in the materials is that this committee will largely stay the same with the number of commissioners. However, Patience is going to be, she is in the executive committee, and because the structure is changing a little bit, we will have a new chair of this committee, and then the composition of members might change. Like some of you all will be moved to other committees. So because there are changes, we thought it might be too presumptuous for the staff to kind of make a recommendation about working with the new chair first. So the first meeting of the year for the Rules Committee, half of that meeting or the first portion of that meeting will be dedicated to working on the work plan, and we'll work with the chair in advance to have it. So there will be a substantive topic for that meeting, but then we'll also talk about the work plan. Once we have the members of this Rules Committee in play, then I'm actually going to be sliding off as the committee coordinator for this committee. Erica Carroll is going to be, we're cycling through just to give staff variety. So Erica Carroll is going to be staffing this committee, and if you guys have worked with her, she's been the committee coordinator for EBR, so she's perfectly poised for this committee because there's a lot of crossover and issues and stuff like that. So you all will be in good hands. I will be attending all of the meetings though, as well as probably Heidi will be attending. So you'll see largely the same kind of staff, and all of our staff work on Rules Committee work, so you'll get an opportunity to still see all of us. And I imagine there's some composition of you all that will stay so that we can have a thorough line with the Rules Committee work, because it has been so intense, and having that historical knowledge, and especially for some of the folks that have been working on the fiscal stuff, there's probably going to be another year of fiscal codification work. We might need at least one member, if not two, from that working group to stay on the Rules Committee. So there's a lot to come, and that's why you're not getting the full-blown kind of work plan discussion today. But Erica will work with the new chair to at least come up with the draft of the work plan to present to you all, whoever the new members are at the first meeting of the year. But I do want to thank you, everyone, because I know this is the last time that this composition of committee members will be together for the Rules Committee. And this is there's a lot of work on this committee. I know you all serve, and and there's a lot of work outside of the committee with the working groups, like with and some topics we're interfacing with, like not just through Slack for public comments, but we're doing focus groups, and we're having lots of touch points. So thank you for your dedication, your hard work, and for seeing some of these topics through for like 3 meetings in a row.
And Dwan, you have been a fearless leader. I have so valued your guidance and keeping me out of trouble, among other things, but also like really being reasonable with us and helping us move forward. And it's been a delight.
Thank you so much, Patience, for your leadership.
So is there anything else we need to talk about right now? I do want to say, if I didn't say it before, you guys who are on the working group for this, Jason, I'm sorry. We didn't do everything, that we didn't adopt it the way you proposed it, because it was a lot of hard work, and I just really appreciate it. And Jacqueline had a ton of great ideas, and it obviously a lot of hard work went into this. Thank you. Selena, you want to add something?
Yeah, I just want to thank the working group for taking into consideration all of the feedback from the community. A lot of the organizations had very specific feedback, and with the exceptions of the sub-grantee/subcontractor issue, it looks like you took all of our questions and concerns into consideration. So thank you.
Great. Are we ready to adjourn? I guess so. All right. Thank you all.
Thank you.
See you next time. Okay, bye-bye.
Thank you.